that. But we also know at this particular stage, and the people of Kenya know, and that is why this is an open court proceedings, that when the courts in Kikuyus were being banned, when in Nyahururu courts and other administrative sessions were being banned, in Dagoretti, and even this hospital, somewhere in Kiserian, and even Homa Bay, which is, of course, that one is an exempted case, that were, when they were being banned, we saw young men on video. These young men, as we speak here today, they have not been arraigned in any court, before any court. So that, Your Honor, because again, it is the kind of thing that was also addressed in the famous court of Githunguri, the question becomes, how, under what circumstances are we having people against whom there is no video evidence are being dragged into courts and being called criminals? But people who have been caught on video evidence, some of them like in Kiserian, when they attacked the hospital, they didn't even bother to mask themselves. But they are not before any court. In case they said, you are going to disgrace the judicial system. You are going, this is going to be an abuse of the administration of justice. Because, Your Honor, if we say, who banned Kikuyu police station, we can only say we must start with those that we saw on the video doing it. But when a man who was not in that video is presented before you, there must be something wrong about it. And the courts must do something about it. Such a person cannot just be processed as a criminal for purposes of making a political statement. Your Honor, the issue of terrorism as a general issue is one that I believe it was Mr. Ondiekien's, one of our colleagues here, who said this is a transnational offense. And it's a transnational offense for one simple reason, that if you say these three respondents and others who shall be defending in other courts are terrorists, everybody from Mossad, from KGB to China, they would be interested to know who are these people. So that the issue cannot be, is a serious issue. So that, Your Honor, when you say that people are engaging in terrorism, you must not take the judicial notice. That is an absolute serious issue. And the respondents are saying, we are here because we are victims of repression. We are here because the democratic freedoms, the fundamental freedoms that are expected in a constitutional democracy, in a functioning constitutional democracy, are being peeled off. There is a clawback on those freedoms that makes Kenya a constitutional democracy. And when we talk about this international issue, that this is not just a Kenyan thing, we speak with the knowledge that, for example, in the current issue of The Economist, which I believe some of us have had an opportunity to go through it, this is how much this has attracted everybody. Because when you say political protests are people who are terrorists, everybody gets concerned about that. And you've had in the current issues of The Economist, where the issue is being raised, that Kenya, which has been the only functioning democracy in East and Central Africa, something absolutely wrong is happening. And Your Honor, part of that thing that is very wrong that is happening is the reason why we are before this court. This freedom, the democratic backsliding that is taking place, must not be permitted. It must be nipped in the bud. How is it nipped in the bud? Your Honor, we had indicated also when we had a previous argument that we are also itching to go to the High Court if that be the case. But Your Honor, before we get there, the first port of call for purposes of protecting Kenyans must be this court. This court must reject the invitation to try and have a scenario whereby state repression is going to be processed against the citizens of Kenya. Your Honor, an application of this nature, point number 2, is an exception to the general rule that on the first day when accused persons appear in court, will appear in court, there should be some evidence against them given by the state. But, Your Honor, the issues here is that because in the particular case, you are having a situation whereby, contrary to the exception that there should be evidence, you are being requested, put these people in. Article 20 of the Constitution and 21 requires this court at the initial stage to ensure that there is protection of the fundamental rights. Your Honor, the third issue is on the fact that, or actually before I go to the third issue, I need to, at this stage, to emphasize this fact came out through yesterday's cross-examination. Your Honor, because the Kenyans in the past have suffered oppression, oppressive prosecution, there's an important thing that happened under the 2010 Constitution, which is that what happened under the 2010 Constitution is that your side, the adjudicator, our side, the lawyers, and the side of the prosecution was put in the hands of lawyers. This is not by accident. This was to ensure, Your Honor, that people in whom the liberty and rights of Kenyans will be placed are trained and cultured to respect freedom, the rule of law, and people and their basic rights. That is absolutely important. A long time ago, I believe Senior Kalonzo, Ireri, and Ondieki are aware of those days. Today we are having 3 lawyers representing the DPP. We used to have the police. We have the DPP Act. We have Article 157 of the Constitution. What is the purpose of that? To ensure that before the respondents or any other person loses their liberty, people trained and cultured as lawyers, people who know the law of evidence, have satisfied the court that we have looked at this matter, and in this matter, it is appropriate that liberty be lost for a while. Your Honor, what is it that we had yesterday during cross-examination? Your Honor, what we had yesterday during cross-examination, and we have it on oath by Desterio. Desterio told us, I prepared this application, CID headquarters. They walked across the room somewhere to Mazingira, as my learned colleague Andrew Muge got it from there, and came with the application to Kahawa. They got it signed. Your Honor, that is very, very serious, because as advocates, and I don't want to deal with it at the advocate's level, I want to deal with it at DPP's level. An advocate, you cannot sign documents prepared by lay people. Desterio is a layman. Desterio cannot prepare an application to take away anybody's right under Article 49. This application, he said it and I repeated it. And I said, oh, awesome, if that is what happened. He said, I did it, there was a typographical error. To say why he said 14 in the application and 30 in the affidavit. Your Honor, the Constitution was written to ensure that prosecution powers are not shared between the prosecutor, between the DPP, and the police. So we cannot have a scenario where you are having documents prepared at CID headquarters, signed by advocates working for the DPP, and say, take away the liberties of Kenyan citizens. Your Honor, Article 157(6) of the Constitution requires the DPP to be independent. That independence, given the Kenya's history, requires independence from two things: independence from the police and independence from the president. That is the history we come away from. So that, Your Honor, when you get into a situation where the DPP is prosecuting on the basis of affidavits and applications prepared by the police, it means that the protections given by the Constitution and Article 157 is being taken away. The duty of this court in those circumstances is not to countenance such a scenario. Because, Your Honor, we used to have the times when, for practical purposes, those powers of detention and prosecution and the police were conjoined in the offices of Bernard Chunga and Francis Sang. We cannot allow a situation where those 1980 days comes back after the 2010 Constitution, that there is a fusion, that the current DPP and Amin want to act together in this kind of manner in the name of fighting criminals. That is not permitted by the Constitution of Kenya. So what's our point? The applications before you is absolutely defective. It is not a DPP's application. The police have got no power under the Constitution, under Article 49, to take away the liberty of any Kenyan citizen. Your Honor, the fourth point is the law of evidence. I hope sometimes I don't see very well. In the case of Githunguri, the basic law of evidence is what? What you can see, what you can perceive, and what is commonsensical to everyone. Now, Your Honor, in the famous case of Githunguri, at a section, they highlighted an important section of the Law of Evidence Act, Cap 80, which is section 3.2 of the Evidence Act. It says as follows: a fact is proved when, after considering the matters before it, the court believes it to exist or considers its existence so probable that a prudent man ought, in the circumstances of the particular case, to act upon the supposition that it exists. Guided by the commentary in Sakal on the provision of section 3.2, as prudent men, which we believe justifiably ourselves to be, we hold that, where applicable, the matters mentioned in the applicant's affidavit, to which he deponed from personal knowledge, have been turned and established into facts. The degree of probability is so high that proceedings by the sound rule of common sense, we are justified in regarding them as certainty and to act accordingly. Applied to this case, what, Your Honor, this means is simple. Given the fact of all that we know about the events from June 25 to Sabasaba to today, the questions would be, in good conscience and based on section 2, can this court be satisfied that the police and DPP has brought terrorists before you against whom you should detain as required by them? Your Honor, when we talk about training and culture, it's because you are supposed to see what is the mischief. And in seeing this mischief, I am urging you that the law itself will not permit you to reject the evidence of our eyes, evidence of our ears, and the videos that we are seeing, and say, these are the people burning police stations and all this. We've seen people walking in the company of policemen in their way to dealing these things. Supermarkets have been destroyed when the police vehicles are just outside there. We cannot ignore these things. And because we are dealing with a political situation and say, whoever the police brings here, we are going to believe it. Your Honor, the reason why it must be lawyers adjudicating people's rights is that it is illegal for a lawyer to be an idiot or a lawyer to act as a person who does not understand reality. If a case comes before you based on alternative reality, on alternative facts, this court is prohibited by law and training that all of us have trained to reject such a charge and to allow any persons to lose their liberty on that basis. Your Honor, talking about that, there is also an important thing that you must understand. I believe you saw Mheshimiwa call me when we were dealing with preliminary issue. Your Honor, amongst those things that we have watched, and we shall be bringing to court if we get to that stage, would be this. A day before, he was arrested, 2 days before. There is somebody called Oscar Sudi who has been protected previously by the constitutions. He said, we are going to arrest you as a precursor to arresting other people. Mukunji the following day dared him. He's a brave Kenyan, and we hail him for that. That, come and arrest me if you can. Well, probably he thought Sudi is a small man. He was actually arrested the following day. And this is why he says that we must make it apparent that when he says that I am here pursuant to persecution, and they have dragged two other people whom I don't know, whom we have just had a chance meeting. One of them is a boda writer. You know, he says there is at least video evidence. The same video evidence that is showing us who is doing all these criminal activities, which he believes they have either been sponsored, aided, or abetted by the Kenyan state, as shown these young men with clubs and weapons that have been molesting other Kenyans. So that, Your Honor, those are the circumstances that we cannot close our eyes, and that our training does not permit us to close our eyes to, and we deal with them as they were. And why should we be very afraid of this? We should be very afraid of this, Your Honor, for one simple reason. That when we speak for the reasons when the trial a long time ago used to happen, and I'm happy I grew up in Nakuru and as a teenager, what would happen would be, you would have a situation whereby people like Karaoke Chotara, a lot of these young people may not know who was Karaoke Chotara, people like Wilson Leitich, they would mention this and this is an enemy of the state. These people would be arrested, taken to Nyayo House, tortured. Some of them would be jailed at night or early in the morning. Others would live there maimed, and others died. And this is the reason, Your Honor, when we say pre-trial detention, and I believe that is why all of us have been constraining to tell you, the reason why we are all here, it is because it starts here. If the Your Honor were to say it is okay, it will open the floodgates. But we are here to say this is not okay. It must start before the judicial officers where they want to start this thing. Your Honor, occasionally, I had to be sent ping by Ndegwa for me to come when we came for the first time to this court. I didn't even know where it was. Because all that we know is that this is a court where terrorists are taken. I've never acted up to today for a terrorist. So I've never come to Kahawa. So I got I got this information that this is where the court is. But there is something there that is important. That occasionally you would hear, when you are dealing with the cause of strikes, that at the CID headquarters Kikiumana, then you hear, huyu tutampeleka, this place is called? Kahawa. That is something we've had in the course of dealing with criminal law. I didn't know why this was the case, but yesterday it started to make sense. Because Desterio testified that he can make documents at CID headquarters, get them signed in Kahawa, and people to be prosecuted in Kahawa. Your Honor, this is something the court may not probably know. But, Your Honor, if this appears to be what is happening, Your Honor, I urge for the dignity of this court and the judiciary, this must be brought to an end. If Kipe Mongai is not representing a terrorist, there is no reason why he should come to Kahawa until the day when a terrorist tells me to defend them. If these people are not terrorists, they go to Runyenjes and they go to other ordinary courts, not to be in such kind of cages that were designed for dangerous criminals. Your Honor, the final point that I wish to make is this, is that in the affidavit, Mr. Gachagua will deal with the bulk of that affidavit, but the only point I wish to point out in this affidavit is this. In this affidavit, we asked, you was a difficult witness, you saw that, Your Honor, but we tried to get something out of him. You gave us an inventory. We saw an inventory. We asked, what are these dangerous things that these people are using to fight? We didn't see, and I've come that through my other lawyers who deals with these issues, and police reports ordinarily, we caught him with guns, bazookas, all these kind of things. It is the reason why people are called terrorists. We got them with hundreds of millions engaging in money laundering, which were not for any investment activity. We believe this is. Here, even the money is not there. Your Honor, we were told there is a notebook. There is people's diary. Ordinary things that all of us have if you go and search Tawakaza, the parking. You take those things, you say, because these men are in possession of these things and a mobile phone, these are terrorists. Your Honor, back in the dark days, there is a Methodist priest who was charged with sedition. I don't know whether Senior Carlos remembers his name. I'm forgetting his name. He was charged with the sedition based on the contents of his diary. We are seeing the reenactment of that. You are being told there is a notebook, there is a diary, personal not Father Kaisa, there was a Methodist priest. It was being done by the law firm of Kamaukuria and Keraito, specifically by Kathuriman Toinoti, my master, who is now judge of the Court of Appeal. And in this Methodist church case, the substance of that sedition charge was what he had written in his diary. What's the point I am making? Yesterday's, the affidavit before you and that inventory reminds us of the day when a Methodist priest had to be charged with sedition based on the contents of his diary and after going through harrowing torture at Nyayo House. Your Honor, the time to stop this is now. I beseech you to uphold the constitutions as your oath of office requires and in accordance with your training and culture as a lawyer. We are most obliged.
Deal with the issues of evidence as they came out yesterday, briefly deal with the questions of law. To that effect, Your Honor, I want to say that I'll be relying on the authority of Oscar Sudi, that is Criminal Revision 208 of 2020. I'll equally rely on Section 2 of the Porter, Section 5, Section 33, and friend Mr. Mburu to distinguish the authorities. Yesterday we were treated to a seekers by a man who never wanted to be referred to as a witness. Yes, Your Honor? Mr. Mburu, to distinguish the authorities. The one you be given to you, I'll share. Yesterday we were treated into a serious seekers by a man who never wished to be referred to as a witness, but who had nevertheless deposed an affidavit. The affidavit, Your Honor, on cross-examination when put to cross-examination as to the content and the truthfulness of his statement, most importantly captioned under paragraph 4 of the affidavit, he simply said that he was not at the scene. That is therefore to say the averments contained under paragraph 4 are not averments that were either perceived, seen, or heard by the witness. It therefore says, Your Honor, and goes without saying that that was pure hearsay, and the same is prohibited under Section 63 of the Evidence Act. The content of that affidavit, Your Honor, which forms the backbone of these proceedings, is that our clients were transacting with finances. In matter of fact, it says the first respondent was transacting monies to a person connected to an array of criminal activities. It clearly came out, and this evidence was not controverted, granted that the DPP waived their right to re-examine, that this is pure hearsay. And therefore, Your Honor, if ground 4 of the affidavit, which forms the backbone of these proceedings, therefore fails on account of the same being hearsay, how then can we probably say that the subsequent paragraphs of the affidavits, which are predicated on paragraph 4, would suffice, would succeed? Your Honor, we pray that the court does find that paragraph 4, which predicates the subsequent paragraphs, is hearsay, on the basis that the witness confirmed that he was not the arresting officer and he never saw or witnessed. Subsequently, paragraph 5, he cannot therefore attest whether the respondents were aboard that motor vehicle. He said that the first time he got into contact with the respondents was at Kibbe police station. How therefore can he say confidently and under oath that the respondents were aboard motor vehicle? No wonder, Your Honor, that is why they have brought the third respondent, who is a mere border rider. When they gave on further examination under paragraph 6, and the details captioned by the inventory, they never said that they recovered a border or a motorcycle in that motor vehicle, simply because there is completely no nexus between the third respondent, the second respondent, and the first respondent. And that is why the inventory does not indicate, that is why paragraph 4 indicates that the third respondent is a border rider who was perhaps in the frolic of his own, but fights himself before you, and whom the DPP want to be incarcerated for a presumption or speculation of an alleged offense. Your Honor, if paragraph 5 therefore fails, it follows therefore that paragraph 6 subsequently fails. The so-called inventory, Your Honor, that has been brought before you does not square out with the criminal procedure provisions. It does not square out with the police standing orders. This is not how an inventory in law is taken out. There is a statutory provision and statutory form of how an inventory must be taken. We are treated into a SICAS, Your Honor. You'll have the opportunity to analyze that paper, a mere A4 paper, inventory. If they intend to rely on it, no exhibit memo. How can this qualify into being an inventory under the Criminal Procedure Code? Is it true, therefore, that the witness and the investigating officer, therefore, could be a competent witness or competent investigator if he does not understand how an inventory is taken out? Number 2, Your Honor, on that basis, paragraph 3 of the affidavit is interesting. That they seek to incarcerate the respondent so that they can investigate the offenses alleged under paragraph 3. Under cross-examination, and when the same paragraph 3 was juxtaposed as against paragraph 8, which my learned senior counsel addressed you on, is that paragraph 8 completely indicates that they are yet to form an opinion as to the charges they were to prefer. When he was put under further cross-examination, why or under which situation or circumstances or wisdom that he applied to bring the respondents before you, he could not answer. If they have not yet formed the opinion of the specific offenses to answer, why are we before you? Why are we before the anti-terror court? If this does not amount to weaponization, intimidation, and harassment. And therefore, if therefore that is a question, does that square out with the mandate of the ODPP under Section 4 of the ODPP Act? Are these some of the cases that can be said that we are pursuing this for public interest? If the ODPP would come before you, and of course we understand the reason why this affidavit is this nature, it was prepared and the application was prepared at that point by the investigating officer. If they have not yet formed an opinion of what the offense is, may be accruing from the circumstances, why were the respondents not taken to Milimani law courts? Why were they not taken to Kiambu law courts? Why were they not taken to Ruiru law courts? Simply because this court is being invited to getting into an arena or to uncharted waters of political weaponization. And political weaponization, when the people are in pursuit of their rights under Article 37. Why is it important, Your Honor, under Article 37? Because the circumstances under which this case finds itself accrued and or arose during those circumstances. One, on the 25th of June, 2025, and on the 7th of June, Sabasaba. All those circumstances were when the people were exercising their sovereignty under Article 1 of the Constitution. And that is why Malayan Senior Counsel can also remind the court to look at, again, paragraph 6, where they are speaking about the diaries, and my learned friend has ably addressed you on it. The same was not even brought before you. The excerpts of the dates of interest, the dates that are of interest, and that's the reason why a diary is available, were not brought before you. The names of the individuals who are purportedly under investigations are not even known other than the name of Evans Ngarenjiro alias Balala. On further cross-examination, whether there is a complaint ensuing therefrom When is the question of a compelling reason an issue? Is the test of the compelling reason applicable during the circumstances as we are faced, or they are applicable during the application for bail or bond? Could we all be wrong? I submit that the test of a compelling reason are not applicable in the circumstances. What is in issue is not an application for bail. What is in issue is the curtailment and the limitation of the rights of the respondents. We shall come to that question of the test. And therefore, Your Honor, before I tell you, I address you on the question of the test as laid out in the case of Oscar Sudi. The DPP or the prosecutor must understand the test applicable. The test applicable is a test as indicated by Justice Ngugi in the case of Oscar Sudi. Paragraph 9, Your Honor, of the affidavit. Again, they were not to specify with certainty, clarity, and conscience. Jerry, help me. Not conscious. Yes? Briefly, sorry, I'm from Kirinyaga. Concisely, where they are interested in. Jerry cannot help me, and she my women rep. They cannot. They could not specify with certainty which areas they are interested in. They say they are investigating Nairobi, Central, and Eastern region. For purposes of record, there is now where in our law that a place called Central is known. You look at the second schedule to the Constitution. We have counties, Nairobi or Eastern region. And there cannot be an invitation to presume that the investigator is addressing counties within the Central. He has indicated that he wants to investigate a region that is not known in law. Number two, Your Honor, even if we were to assume that they want to investigate the counties within the what used to be the former Central region, which county are they interested in? There are over 10 counties within that region. And then again in Nairobi, where are they exactly interested in? Which building, which street? Where is the specificity of these? So that then you can say when we release them that they will then interfere with that evidence somewhere in Nairobi. This is what we are calling fishing expedition, the embarrassments of the ODPP. You know, further to the issue of cyber forensic analysis, the witness confirmed and the DPP has admitted that there is no possibility that the respondents would interfere with the forensic investigation being undertaken at the DCI headquarters. And then even if we were to assume that there would be interference, then what is the integrity of the process? Who should protect that integrity? The respondents? How would they protect it? It is within their armpits to protect the integrity of that process. Permit me, therefore, to draw your attention, as I come to conclusion, to the test that was applied in the case of Sudi by Justice Professor Ngugi, as he then was. He applied two tests at paragraph 24 and paragraph 24. He says the first, so even while accepting that the text of Article 49, Clause 1, paragraph F, may in certain circumstances and contexts comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reason for the continued detention through the state, application to have him held by the state must satisfy a double test. The first test, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to the existing exceptional circumstances. That is the first test. The test is not that of a compelling reason. Number two, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial. One, the interest of the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice, and the interest of the victims of the crime where appropriate. That is the test. We urge Your Honor to rely on this test and disregard the test proposed by the ODPP. When you retire to make your findings, Your Honor, I would invite you to look at paragraph 27 of the said ruling, 28 and 27 and 29. But of most important is paragraph 29 from B, to state that, and remember, this is a case, Your Honor, just to contextualize it. By the time this ruling was being delivered, Oscar Sudi, who authorized the arrest of the respondent, was a serving member of parliament. To say the state made no efforts whatsoever to demonstrate which witness would be interfered with and how such interference would happen at the investigation stage, given the offense contemplated. What this ruling, sorry? Paragraph 29, Your Honor. Paragraph 29 is speaking to the question of the interference of the witness. First, the argument the applicant is likely to interfere with witnesses because he is a man of immense persuasion and influence seems eminently pretextual for at least two reasons. You'll see that the question of the social status and social standing of an individual cannot be the test upon which, or cannot be a ground upon which an application such as this one ought to be admitted. The High Court is saying that you cannot simply say that Honorable Mukunji, who is a member of parliament for Manyata, has the capacity to interfere with everybody in Nairobi, even witnesses that he does not know in Central Province, witnesses that he does not even know or disclosed in Eastern Province, just merely because he's a member of parliament. The court is saying that is not the test. That is not the ground. And suffice to note, Your Honor, that do you understand why the second respondent is before you? The description given by the IO is that the second respondent is a journalist. For the mere fact that the second respondent is a journalist, he finds yourself before you. What is that the state did not want the journalist to cover? What is that they never wanted the journalist to expose? And is being a journalist a crime? Is it why the state was ordering for the closure, arbitrary closure of the media? And you know why the journalists were on the street that day, Your Honor? It's because the court rose up to the occasion to defend our democracy, to defend our constitution, to defend our rights. That is why the second respondent was on the street on that day. Otherwise, he would have been at home had it not been for the judicial power. What am I saying, Your Honor? I am saying that you have the power and the authority to rescue the country from this trap of political intimidation, political harassment, and political manipulation. Finally, Your Honor, I did indicate to you that I would address you on paragraph 5 of the Porter.
No, just to indicate that time has lapsed. We are now beyond the 1 hour that we.
How does that prejudice the ODPP? I'm just about to finish. Your Honor.
We have other matters that we have to deal with. We don't want to find ourselves in a situation that we found ourselves yesterday.
It is the court's time.
Court is controlling time.
Your Honor, I am most obliged by the protection granted by the court against the tyranny of the ODPP. Your Honor, paragraph 2 of the Porter has indicated that has given or listed the properties that are capable of being applied towards the commission of a terrorist act. Paragraph 2. Section 2, that of the Porter, the definitions. One of those is the funds. The application before you is predicated on the availability of the funds. Therefore, if the inventory, the purported inventory, and I have to rely on it for lack of otherwise, as embarrassing as it is, if there was no funds that were captioned by the inventory, where are the funds? Who took them? Why did the IO take the funds belonging to a crime? Why has he interfered with the integrity of that crime if it was otherwise committed? The absence of funds in the inventory can only communicate the lack of good faith in these proceedings as elucidated in the case of Oscar Sudi. There cannot be any other conclusion, Your Honor. Number two, Your Honor, permit me to address you on the question of the terrorist property meaning. Again, the meaning of terrorist properties. Terrorist property, again under Section 2, proceeds from the commission of a terrorist act, money or other properties. If money is lacking, they have not said that the member of parliament identity card was an accessory of, or a tool of committing the crime. They have not told you the member of parliament's card that was a parliamentary card or his iPhone or anything were accessories. The case is predicated on the issue of money. And suffice to note, we have all agreed that the affidavit is laced and tainted with hearsay. Permit me, as I sum up, to address you on paragraph 33. Yes, paragraph 33. A police officer who detains, of most importance, Your Honor, because I know you refer to the law, is paragraph 33, subsection 2. Section 33, subsection 2. It will become relevant when you're making your decision. Equally, section 33, subsection 4, and subsection 5. That they are not compelling. The court is being told, a court shall not make an order for the remand in custody of a suspect under subsection 4 unless there are compelling reasons for believing that the subject shall not appear for trial. But this compelling reason is not at this stage. It's when the trial itself has commenced. That's the distinction I wanted to make. Paragraph 30, section 35, on the circumstances under which the limitation of rights can ensue. Section 35, of most importance, is section 35, subsection 2, paragraph A, B, and C. Those are very important, and also subsection 3 of section 35, subsection 3. We urge you, Your Honor, to find that there are no reasons that have been brought before you. The same has failed to meet the test under the case of Oscar Sudi, and that this application ought to be dismissed and the respondents be set free. Your Honor, the respondents, but I shall make that application after you have made your decision. Again, permit me to just go slightly backwards. In the case of Oscar Sudi, again, look at paragraph 23 of the said authority and say what the judge is saying. 23, Your Honor. This is an act in futility. The application is meant to silence the dissidents, individuals who may not agree with the current existing status. Is a political persecution. It will almost amount to a detention without trial if the trial is based on speculation or the presupposed trial is based on speculation. Kindly put a lot of weight to the evidence that came out during cross-examination and the inability of the witness to answer the questions as put to him by the defense. Permit me to invite Mr. Moro to distinguish.
Before that,
Your Honor,
sorry,
I
Mr.
have
Onyeka.
4 points.
Just okay. Since you're on your
Let me raise this issue.
perhaps, Your Honor, because of the gravity of the matter, please bear with us. We ask our colleagues in the prosecution to just bear with us. It's critical. Thank you.
1 minute, Your Honor. I'm raising 4 constitutional questions in addition to what my learned colleague raised, which binds you. Yes. My name is Onyeki. I'm a distinguished constitutional practitioner. Yes. And the 24-hour principle is known as the Onyeki principle.
I can attest to that.
Yes. Yeah. So, Your Honor, I just want to raise 4 issues which cover the principles and values of the Constitution. Number 1, look at the preamble, the issue of recognition. Your Honor, in the preamble of the Constitution, Kenyans thanked God for giving them a new constitution. And then the preamble they said, recognizing the aspirations of all Kenyans, that they want a government based on human rights, equality, freedom, democracy, and the rule of law. And those values, Your Honor, are replicated in Article 1, Article 10, 1, and Article 10, 2. Your Honor, a member of Parliament is not anybody. A member of Parliament under Article 94 is having a constitutional mandate to oversight the executive and also approve budget for the judiciary. Now, all of a sudden, this member of Parliament can't even move. He is a perceived terrorist on suspicion. So I urge you to look at that aspiration. Number 2, Your Honor, as you retire to consider this ruling, I want you to look at Article 24, Clause 2C. It is very specific that even when you are being moved to restrict a right or limit it, you should not limit it to the point that it derogates from its core or essential content. My learned colleague espoused those rights of liberty, dignity, and freedom to associate. Your Honor, even when you want to limit, you cannot limit it to the extent that it deletes its essential content. And Your Honor, 14 days removes that essential content of that right. I want to take you now to the third issue which I'm raising, which is under Article 49, 1F. That's what I want you to look at. This application is there to limit the rights of the respondents. For 14 days, they are not even sure. They came with 30, they downgraded to 14. But Your Honor, what is the threshold? The threshold is found in Article 49, 1F Roman 1 and 1F Roman 2. It says if you arrest any person, then you have to bring him to court, which is a court of competent jurisdiction, within 24 hours. So what are the exceptions in this case? If there is anything that they want to limit their rights, then the threshold you want to measure is 24 hours, because the Constitution has defined when you have to bring somebody to court. So asking for 14 days, Your Honor, is not reasonable in a democracy, in a country that respects the rule of law, in a country that is a member of the Commonwealth and a member of the United Nations. Now, my learned colleague talked of the autonomy of the Office of the Inspector General and the ODPP. Your Honor, on that issue, I ask you to look at Article 249, Clause 1A and 1P. 1A, and I can explain the brief historical background. Article 249, Clause 1A and 1B. Your Honor, Senior Counsel explained the background of the registration, the enactment of the 2010 Constitution. Why did the 2010 Constitution create so many commissions and independent offices. You find that in Article 249, 1A and 1B. Your Honor, in 1A, it says that constitutional commissions and independent offices must protect the sovereignty of Kenyans, democracy, and constitutionalism. What is constitutionalism, Your Honor? Constitutionalism simply means a limited government. That's why there are checks and balances. That's why these institutions were created. And that's why there is parliament, there is the judiciary, and there is the executive. And then there are independent offices which should implement this constitution. So what, Your Honor, I'm saying, in exercise of their constitutional mandate, they cannot come here and swear to preach the constitution which they have sworn to protect, promote, and fulfill. You will get that in Article 21, Clause 1. All state officers, all state organs are obligated to observe, promote, protect, and fulfill the human rights, which my learned colleagues have indicated. So, in a nutshell, what we are saying is this, Your Honor. There is no competent application before you to warrant you to issue orders that will curtail the liberty and the freedoms of the respondents. And for that reason, I rest my case, Your Honor, that the enduring values in this constitution is that we have a judiciary that can protect the rights of any person wherever they are represented with them. I rest my case.
Your Honor, if it may please you. Yes, my name is Sakimpa. Your Honor, I'll be very brief. So, yes, Your Honor, this is very key. These are legal issues that we do request that we.
Your Honor, there will be, just for full disclosure, there will be young three men. Just to say within 2 minutes, the only reason for that, and we had asked for our learned colleagues to understand, is that our senior Kalonzo Musyoka, after 5 years, probably might be the president somewhere. I may not be available to lead in Kenya, and I may not be there to deal with, to lead everybody and Odieki, because he's an old man now. So the young men who will be defending the constitution needs to say something. Let them just say in 2 minutes each. We beg you.
But Your Honor, I wonder whether there shall be constitutional violations when he becomes president.
No.
Perhaps you are not supposed to be there even now.
Yes, Your Honor. Yes, Your Honor. Yes. So, Your Honor, I want to begin with a preliminary legal question that the current detention of the respondents is actually unconstitutional. And I'm going to give the basis that there is no charge or holding charge that has been presented as against them. So, Your Honor, I want to rely on the authority of Michael Rod. Arrested and arraigned in court within 24 hours. Michael Rotich versus Republic. It's a 2016 decision. Should I proceed, Your Honor? Yes. So this is what the learned judge said. That is Justice Kimaru in that matter said that there isn't trend where a person is arrested and arraigned in court within 24 hours, specifically for the prosecution to seek extension of time to detain such person without any charge or holding charge being preferred against them is unconstitutional. So that is what the judge said. So, Your Honor, yes, Your Honor, and that decision is binding upon this court. And we remember that 3 days ago when we appeared before this court in other matters, the prosecution had presented a holding charge in respect of some of the suspects and also charge sheets in respect of the others. So in this particular case, neither a charge or a holding charge has been presented before this court. So this is what the court continued to say, that such holding charge will enable an accused person to know of the reason for his arrest as provided under Article 49A of the Constitution. It will not do for the prosecution to present a person who has been arrested in court and seek his continued detention without a charge or a holding charge being lodged in court. Your Honor, none has been lodged before this court, neither a holding charge or a charge itself has been lodged before this court. And the judge continued to say, it is unlawful for the police to seek to have a person who has been arrested to continue to remain in its custody without a formal charge being laid in court. So, Your Honor, I think it is very clear from that particular provision that without a charge or a holding charge, the continued detention of the suspect or respondents herein is unconstitutional. And, Your Honor, that has a basis because the reason why a charge or a holding charge is required is so that the suspects are able to properly understand which particular charge they are facing. So in this particular case, the miscellaneous application that is before you lacks specificity in the sense that it does not specify which of the respondents is being charged with which particular offense. And that was the whole basis why the court was saying that there has to be a charge or a holding charge so that the accused person properly understands which charge has been presented as against them individually, or if it's collectively, then that has to be clear. So, Your Honor, that decision has been supported by, in the Oscar Sudi case that has been stated by my learned friend, Mr. Ndegu Anjiru, and Professor Joel Ngugi, in agreeing with that position, said as follows, that there are good reasons for this purposeful reading of the Constitution. Why should the police arrest a citizen if they do not even have a provisional view of the offense the citizen has committed? It would seem repugnant to the ethos of constitutional justification of the exercise of power and authority in which our Constitution is steeped to encourage such practice, even if not categorically unconstitutional textually. So in many cases, such police action would be, in the context and effect, unconstitutional. This would be the case where the police conduct reveals a pattern or desire to overreach or to deploy the criminal justice system in a manner which unnecessarily diminishes the personal liberty or autonomy of the arrested person. So this is exactly what is happening, Your Lordship, Your Honor, that the criminal justice system in this particular case is being used to settle political scores and not to, otherwise a charge or a holding charge would have been preferred as against the respondent. So, Your Honor, there was another issue that was Mr. Ndegwa had pointed, that is section 33(5) of Porter. Your Honor, and that provision is very clear, subsection 5. A court shall not make an order for remand in custody of a suspect under subsection 4C unless A, there are compelling reasons for believing that the suspect shall not appear for trial. That is the first compelling reason. Your Honor, look at the application and the affidavit. None has been deponed to show that either of the respondents will not appear in trial. The other one is the the other compelling reason is interference with witnesses or the conduct of the investigation. So, Your Honor, this is the darling of the prosecution. This is what they are saying is what they need for them to conduct the investigation. So, and Your Honor, if you look at paragraph 9 of that affidavit, as well as this was confirmed in cross-examination by the accused person. So they're saying that under paragraph 9, they're saying that the investigation team is yet to conduct the following. Number 1, recording of statements from witnesses and victims, forensic analysis of mobile phones, which they confirm they have already collected, retrieval of financial records connected with the respondents, and Your Honor, they have confirmed that they are in possession of all these items. So the only thing they require is for them to analyze. So Your Honor, the question is whether the respondents need to be detained for this to proceed. So Your Honor, and I have an answer where the court in the case of Betty Jemutai versus Republic, it's a 2018 decision. It has answered that question for Your Honor. It will be very easy for you. And this is what the court said, that I do not find that the police offered good reasons for the continued detention of the arrested persons because the matters used to just Number 1, by taking witness statements, obtaining call data from applicants, and securing forensic report on cyber crimes. All these things could have been accomplished even with the persons all being out of custody. So, Your Honor, the respondents for the prosecution to be able to conduct this investigation. In any event, it was on cross-examination, the IO confirmed that these analyses are done at the DCI headquarters, where the respondents neither work nor have access to those particular facilities for purposes of conducting those investigations, those analyses. So, Your Honor, in the end, what we are saying is that there is no need to detain the respondents, as the prosecution can still conduct that investigation without the respondents. And Your Honor, the other issue of interference of witnesses, there was a decision that was quoted by the prosecution, that is Njau versus, and two others versus the Republic. Your Honor, and I think counsel should have properly informed the court of the import of that decision, which we are going to differentiate right now. In that particular case, the court actually laid out the threshold for the court to consider in terms of witnesses. And at paragraph 14 of that decision, the court stated as follows in terms of the threshold for interference, that accordingly, the specific instances or likelihood of interference with witnesses must be laid before the court with sufficient detail or evidence in support thereof as to persuade the court to deny the accused person bond on this ground. So, Your Honor, it was very clear that in this case the court had already laid out that sufficient detail and evidence must be provided. In this particular case, Your Honor, the witnesses are yet to be identified by the prosecution, and no evidence has been provided to show that the accused persons, the suspects, will interfere with witnesses who are actually unnamed. And in that case, whereas the holding is what they say, that was because the prosecution in that particular case was able to list the witnesses and actually provided evidence that other witnesses refused to testify on that case. So there was sufficient evidence in that case which warranted the court to make a determination that actually they would have interfered with shown. No OBS extracts have been presented to show that anyone has complained of any interference from the respondents. In fact, the only reason they have is that they're saying that they accused the first respondent, because he's a member of parliament, has the capacity to interfere with witnesses. Your Honor, and I have a decision in the case of Panju versus Republic. Panju versus Republic, it's a 1973 decision. PANJU versus Republic. It is a 1973 East Africa law report. Your Honor, and in that particular case, the court was very clear that the court will not deal with speculation, as is the case herein. This is just because someone is a member of parliament, without providing material before the court to show interference, is speculative. And the court said that in dismissing the prosecutor's fear of interference with witnesses, at least some facts should be led to the court, otherwise the court to speculate. And we do submit that what the prosecution is doing is speculation. There is no evidence whatsoever that has been presented before this court to indicate that the first respondent will interfere with the witnesses. So finally, therefore, Your Honor, what then does the court needs to do under section 33(5) of Porter? So I have already said that for the compelling reasons, there is no reason in terms of interference of witnesses. B said that it is necessary to keep the suspect in custody from the protection of the suspect, where the suspect is a minor. So in this case, Your Honor, there is no safety concern as to the respondent. In fact, the first respondent is a member of parliament who is section 33(5) of Porter, on what the court needs to consider in an application like this. C is the suspect is serving a custodial sentence. In this case, that is not applicable. And D, the suspect having been arrested in relation to commission of an offense under this act has breached a condition for his release. Your Honor, that is not applicable in this case. So it is therefore our submission respondents be unconditionally released based on the authorities that we've already mentioned.
Thank you.
I am most obliged.
Thank you. Kumo, if 1 minute, because we want the ruling to be next.
Your Honor, I believe we can now go back. Yes, and Your Honor, in the interest of time, I'll strictly limit myself. Get advantage position. I want to. Kurenga is my name. Kurenga is my name, Your Honor. Yes, Your Honor, I want to briefly address the court on internationally agreed principles on pretrial detention, and my submission will be premised on Article 9, Sub-Article 3, or the International Covenant on Civil and Political Rights. And Your Honor, is the only thing I'll paraphrase
that is the ICCPR, that it shall not be the general rule that persons awaiting trial, yes, that is Article 9 sub Article 3 of the International Covenant on Civil and Political Rights. We state the Covenant on Civil and Political Rights. We state the Covenant on Civil and Political Rights. We state the Covenant on Civil and Political Rights. We state